The first outcomes we're going to cover include Section 44 to 46 of the Companies Act. Section 44 applies for financial assistance for subscription of securities. In other words, providing a person with financial assistance to purchase shares in the company. Section 44, financial assistance for subscription of securities, do not include when the financial assistance is part of the primary business activities of the company. For example, a bank providing loans. It does, however, include any loans or provisions any other company would make for the assistance to buy securities. The first requirement is that for all other companies is that the MOI of the company should allow it. And if there are any other additional provisions stated in the MOI to be satisfied in such assistance, that should also be complied with. And in addition to this, should the board also authorize the financial assistance. However, this can only be done, firstly, in cases of an employee share scheme, or if a special resolution was taken within the preceding 2 years regarding a specific group that would be allowed to receive financial assistance, or for an individual to receive financial assistance for purchasing securities in the company. This can only also be allowed in instances or in cases if the company is still liquid and solvent or passes the liquidity and solvency test after the loan was provided. And it's also required for the loan terms to be fair and reasonable. For example, the interest rate should be market related. In the cases of non-compliance of Section 44 of the Act, firstly, such an agreement would be void. And secondly, directors who attended the meeting where such assistance was authorized, as well as those who did not vote against it during that meeting, could be held liable. Section 45 of the Companies Act applies to loans or other financial assistance to directors of the company, irrespective the reason for the loan or financial assistance. This section excludes a loan in the ordinary course of the business, for instance a bank, or any advances paid to a director for legal or any other expenditure carried on behalf of the company, or to defray employees for any costs carried on for removal. Otherwise, the MOI must allow that a loan is provided to the directors, and if there are specific requirements to be met in the MOI, it should also be met when loans are provided to directors, and the board should also authorize such an agreement. Firstly, this would only be allowed in cases for an employee share scheme, or if a special resolution was taken within the preceding 2 years relating to a loan for a specific group or individual. And this would only apply if the company is still liquid and solvent after the loan was provided, and if the loan terms are also fair and reasonable. This section, in addition to Section 44, will also require the board to inform the shareholders by means of a notice about any such an agreement within 10 business days after the decision was taken to provide the financial assistance. And this applies when the value of the loan is larger than 1% of the net worth of the company. In other words, if the net worth of the company is 1 million rand and the loan is 1.1 million rand, after 10 business days 10 business days after the loan, the shareholders should be notified. Or otherwise, say the net worth of the company is 1 million rand and the value of the loan was 800,000 rand. Within 30 days after the year end of that financial year, should the shareholders be informed about such an agreement. Non-compliance with this section would also result in the agreement being void and all directors being liable who attended the meeting and who did not vote against the decision. I'm not going to discuss this slide in detail, but this is a nice summary where I've compared the two sections with each other. Section 44 versus section 45. The next section, section 46, is about distributions of the company that should be authorized by the board. These distributions include any money or property transferred to shareholders of the company. The only circumstances that will allow this is if it's pursuant to a legal obligation or a court order, or if the board authorized the distribution by means of a resolution. And this can only happen if it reasonably appears that the company will satisfy the liquidity and solvency test after the distribution, and the board also acknowledges by a resolution that they've performed the liquidity and solvency test and reasonably concluded that the company will satisfy the test after the distribution. If this distribution does not realize within 120 days after the above mentioned, the board should reconsider the solvency and liquidity test and adopt a further resolution for the distribution. Again, in this section, and this distribution or the agreement is void when not complying with the section, and the directors who attended the meeting and did not vote against it can be held liable. The next sections are sections 75 to 77 of the Companies Act. Section 75 applies when a director meeting is held, but one of the directors has a personal financial interest relating to a decision that will be taken during the meeting. First of all, the purpose for this section is to avoid that directors have a conflict of interest between the best interest of the company and their personal best interest. And in general, this section basically states, or the general statement of this section is, when a director acquires a financial interest, which is, or could cause a conflict between him and the company, it should immediately be disclosed to the board. In cases when a director or a person related to that director has a personal financial interest in a matter that will be considered during a director's meeting, the following will apply. Before the meeting, the director must disclose his or her interest. Also, provide or disclose any material information relating to the interest. Or is allowed or may disclose observations or insights if requested by the other members of the board. During the meeting, the director must leave the meeting after the disclosure was made and must not partake in the consideration of the matter during the meeting. While absent, the director is regarded as present to satisfy the minimum quantity of directors that is required for a meeting to take place. However, while absent, the director is not regarded as present to determine sufficient support in relation to any resolution. At no stage is a director allowed to execute any document on behalf of the company in terms of such a matter unless directed or requested by the board. The decision of a board taken relating to a matter where a director has a financial interest and a decision was made during the meeting will only be valid when the requirements of this section has been complied with, or the meeting was treated in terms of this section, or if this section was not complied with, the decision relating to the agreement or relating to the matter where the director or a director of the company has a financial interest was subsequently ratified by the shareholders. In other words, telling the shareholders afterwards, listen, we didn't comply with section 75, where Director A has a financial interest in, but can you ratify this for us? Then the decision could still be valid. Or if a court subsequently also declared that as valid. Section 76, Standards of Directors' Conduct. Directors of a company must not ever use the position of the director, of being a director, or the info obtained because of the position of being a director, to gain any advantage for that person or a related party. In other words, personal advantage for the director or a party related to the director. Or use a position or information to knowingly cause harm to the company or a subsidiary of the company. Any information should be communicated with the board. In other words, any information that can have an effect on the company, a director of that company should communicate that with the board. Unless such information is regarded as immaterial to the company, or if the information is generally available to the public or public knowledge, or a director is bound not to disclose it due to legal or ethical requirements. And this can literally be any information that comes to the attention of the director if the information could have an effect on the company. When acting in the capacity of a director, the director must exercise all the powers and duties and actions, firstly in good faith, in other words, honest and proper, must act in best interest of the company, with a degree of care and skill and diligence that could reasonably be expected of a person while carrying out functions, or just from the perspective of the general knowledge, skills, and expertise of the director. Liability of directors and prescribed officers. Section 77 of the Companies Act says that a director may be held liable when a breach of fiduciary duty, in other words, expected due to the position of trust of the director, happens in terms of, or as required by section 75 or 76, or in a breach in terms of any other provision of the Companies Act, or in terms of the MOI of the company. A director is liable for actions where the director lacked authority to do so or to take the action, in the cases of reckless trading, and for any fraudulent act or omission. Also, if a director sign or publish false or misleading financial statements, or an untrue perspective or written statement to the shareholders. when a director is present at a meeting and do not vote against the following. In turquoise, I highlighted that because it relates to shares, and in brown, I highlighted that because it relates to financial assistance, just making it a bit easier to remember. So firstly, authorizing or issuing unauthorized shares. Securities are options. During meeting, if the director is present at such a meeting, the director can be held liable. The provision of financial assistance to buy shares in the company, not meeting the terms that we discussed earlier in terms of section 44 or the MOI. Or to providing financial assistance for a director and not meeting the terms of requirements of section 45 or requirements of the MOI. Or taking a resolution to make a distribution to shareholders that do not comply with section 46. Or in a case, again, we're back at shares in turquoise, where a company acquires its own shares, not complying with section 46 or section 48. And lastly, the allotment of shares not complying with the Act, Chapter 4, and that is any requirement relating to a public security offering.